I'd like to now declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the Australian Security Intelligence Organisation Amendment Bill number 2, 2025. These are public proceedings, although the committee may agree to request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee today, they are protected by parliamentary privilege, unless you're giving evidence from outside of Australia. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as contempt. I remind all present that as Chair, I'll ensure the proceedings are conducted in an orderly, respectful and courteous way. In accordance with the committee's resolutions of August 26 of this year, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published also on the Parliament's website. The hearing today has been conducted with some members of the committee and witnesses appearing by video conference. Members and witnesses participating remotely are reminded to mute your microphones when not speaking. On that note, I'd like to now welcome representatives of the Law Council of Australia. Good morning, and look forward to your evidence today. Now, for the Hansard record, could I ask that you all please state your full names and the capacity in which you appear before today's hearing?
I'm Lloyd Babb, SC. I'm Chair of the Law Council of Australia's National Security Working Group.
Good morning, Lloyd.
I'm Associate Professor Rebecca Ananian-Welsh, and I'm here in my capacity as a member of that same working group.
Excellent. Thanks, Rebecca.
Thanks, Chair. I'm Nathan McDonald. I'm Deputy General Manager of Policy at the Law Council Secretariat.
All right, thanks, Nathan. Now, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Now, due to the short time frame the committee is working within, please answer all questions or provide as much information as you can to the best of your ability today, as answers to any questions taken on notice will need to be provided within 24 hours of us receiving the Hansard transcript. Now, I want to ask you, did you have an opening statement that you'd like to make this morning?
Yes, thank you. I'll provide the opening statement.
Thank you.
The Law Council acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respects to the elders past, present, and extend that respect to all Aboriginal and Torres Strait Islander people who might be listening today. We welcome the opportunity to appear today in relation to the ASIO Amendment Bill number 2. We acknowledge the important role that ASIO plays in identifying and responding to national security threats and support measures that empower our intelligence agencies to keep Australia and Australians safe. We seek to ensure that such powers are reasonable and proportionate, contain adequate statutory safeguards to protect human rights, fundamental freedoms, and respect of the rule of law principles. ASIO's questioning powers were first introduced as an extraordinary, limited and temporary measure to address the threat of mass casualty terrorism after 9/11. Their extension over time and the accretion of subject matter does not diminish the ways in which these powers remain exceptional in the Law Council's submission. ASIO's questioning warrant scheme remains exceptional because it can be utilised against non-suspect third parties, involves coercive questioning powers with incidental powers of detention, especially where immediate questioning is sought, can be utilised when criminal charges are imminent and underway, is subject to non-disclosure orders, imposes limitations on the subject of the warrant's choice of legal representatives, allows for questioning of children as young as 14, and contains powers to remove legal representatives without warning. This bill proposes to make two significant changes to ASIO's compulsory questioning warrant framework. Firstly, it proposes to extend those powers to almost all aspects of ASIO's security mandate. And second, by proposing the removal of the sunset clause, this bill seeks to make these powers a permanent fixture of Australia's national security law. The Law Council welcomes the additional safeguard measures in the bill, such as grounds for disqualification or dismissal of a prescribed authority, as well as the improved reporting obligations to the Attorney General. We are nevertheless disappointed that these additional safeguards represent marginal improvements rather than more robust protections. The Law Council is further concerned that this bill overreaches in 4 significant ways. Our concerns are with both what is in the bill and what's been left out. First, we're not satisfied that the evidence base and the arguments for expanding the questioning warrant scheme to ASIO's full security remit has been adequately justified. Inconsistent public remarks by ASIO and the department about the utility, necessity and proportionality of questioning warrants under each head of security mean that this proposal requires detailed analysis and consideration. These are extraordinary powers and they shouldn't be extended without a clear and compelling public justification. Second, the Law Council doesn't support the removal of the sunset clause. The sunset clause is acknowledgement of the extraordinary status of the questioning warrant framework. It forces a public debate regarding intelligence gathering powers that undermine the possibility of fair and adversarial criminal process for those questioned. Periodic and public scrutiny by this committee encourages the judicious use of questioning warrants. The sunset clause adds consequence in the Law Council's submission to this committee's oversight. Third, the bill does not follow through on recommendations made only last year by ASIO and the department to remove minor questioning warrants. This omission appears to represent a significant policy reversal in government opinion regarding the appropriateness and necessity of minor questioning warrants. The Law Council is not convinced that adequate justifications for retention have been provided. And then finally, we consider that confidence in the scheme would be improved by requiring judicial rather than ministerial ratification of warrants. Restrictions on lawyer involvement and discretionary powers to remove lawyers should be repealed. Legal representatives ought to receive sufficient information about a warrant in order to be able to provide meaningful advice to clients. And with that, we thank the committee for your time today and we're happy to respond to your questions.
All right, thanks very much for that, Lloyd. Now, Senator Cash, are you there?
I am. Thank you very much, Chair, and thank you for that opening submission. You refer on page 10 of your submission to what you say is, and I quote, the steady expansion, close quote, of some of the powers at the heart of this legislation, and you've obviously just referred to it there in your oral statement. Can you talk me through any data or practical evidence that you would cite as demonstrating abuse or overuse of these laws during the more than 20 years that they've been in operation?
Thank you for the question. No, we can't point to abuse or overuse, and in a way that is the crux of our submission. Rather than there being overuse, there's been a lack of use of the powers. And we detail in our submission a table setting out the very infrequent use of the powers, which can be looked at in one of 2 ways. I suppose that ASIO and the department say that it's being used judiciously. Another way of looking at it, and the way that I would urge it to be looked at, is that the powers are not necessary, that they're used so infrequently that it's hard to see a justification for expanding the powers.
Look, thank you for that honest answer. Do you accept the thrust of ASIO's public commentary over recent years, which points to more dangers and more risks to our national security than they have been in the past?
That is, I think, possibly not a completely accurate description of what ASIO has been saying publicly. And one example where they haven't said that is in relation to border security. I think the public statements in relation to border security have indicated that they don't see it as an increased threat, and that is a good reason for not expanding these powers to cover that particular head.
What about, though, the more global situation and obviously the risk of, say, state actors on Australian soil?
Yes, look, I do accept to the extent that it's able to for me to know what ASIO have said about increased risk. But one of the challenges, Senator, is that in order to have public confidence in the need for these provisions, we need justifications to be outlined. And in those areas where they are substantiated, we have been supportive of the expansion of powers. It really is a question of getting the balance right, and for there to be confidence in civil society and important agencies like the Law Council that the changes are necessary and proportionate, and that has to be made out. And you know, there are stronger arguments in relation to some expansion than others.
You, I assume, though, have full confidence as the Law Council of Australia in ASIO when they do make statements which point to more dangers and more risks to our national security than there have ever been in the past, given in particular your comment that, and I quote, to the extent that I know is what you said. So I hope you're not saying that you don't have full confidence in ASIO.
Sorry. What?
Do you have full confidence in ASIO when they say statements to the effect that there is more danger and more risk to our national security than there has ever been in the past?
Look, I would look at each statement by any public agency and assess it against the available information.
Can I perhaps jump in here, Senator?
Yes.
We're, of course, aware as a civil society organisation that we're not privy to all of the information that is behind ASIO assessments and statements, and we appreciate that. And we do have faith in their statements when it comes to security. I think what Mr. Babb was describing is just the need to publicly demonstrate that there is a gap in the current infrastructure that requires these expansion of powers. And I think multiple commentators, including the Scrutiny of Bills Committee and Human Rights Committee, have pointed out that the explanatory material accompanying these reforms just don't seem to have that justification set out in the level of detail that we would expect.
Thank you for that clarification. I do appreciate that. Just in relation again to the submission, it criticises the removal of powers in respect of lawyers' presence at questioning, especially when you go to pages 19 and 21. Beyond what you say in point 65 of the submission, can you provide examples historically where a lawyer has been wrongly removed under the terms of this legislation from being present at questioning?
I'm not able to provide an example, Senator. No.
If I could
Is
just,
anybody else at the table able to assist the Senate committee?
one thing I think I would just emphasise is that these are designed to be incredibly secret, covert powers. And so there's very little information that we have about these powers, which is one of the reasons why we really get behind the additional oversight that's required. So the importance of having environments like this where Parliament can come and interrogate the use of the powers, the importance of having reporting, the importance of making sure ASIO or anyone else is really justifying why they need these powers here in these forums, because once they're in use, we know very, very little about their use. We can trust that they're being used properly, but there's no way for civil society or the legal system even to really interrogate the use of these powers. So no, we don't know much about the use of these powers. We know that they haven't been used very much. So since 2022, there's been zero. Why? We as civil society can't be sure. Secrecy is absolutely required, but ramping up that oversight at those critical junctures, when the warrant's issued, when it comes back before Parliament, when the sunset clause is up, that becomes super critical for these powers.
Just going back to the question though, your submission itself criticises the removal in respect of lawyers' presence at questioning. So are you saying, based on your answer, you don't know if a lawyer has been wrongly removed or not?
I don't think we could possibly know that.
And
considering
why is that?
Because the legislation has all sorts of secrecy requirements around it where it would be an offence for people to talk about what goes on in that room.
But then why would you criticise the removal powers if you don't know?
Because as a general principle, providing people who are being interrogated by the state with legal representation or the ability to get legal advice is a general rule of law principle that the Law Council stands behind.
Okay.
Deputy.
Chair, I've got two more questions. One just quickly flows on. Am I able to ask them?
Yes, that's fine.
Okay, thank you, Chair. You argue that lawyers should receive more information about the grounds for questioning a warrant, and I'll ask this question in two parts. The first is, how do you reconcile that argument with the need to protect sources, methodologies and foreign intelligence relationships? And then the second part is, isn't it the case that broader disclosure could increase the risk that targets learn sensitive operational details, with the effect, therefore, of rendering the entire regime less effective?
It's a question of balance, Senator, and it's important if we're going to genuinely have lawyers assisting that they've got enough information to understand the scope of the warrant and to be able to assist their client. These are the powers would enable someone who's facing criminal charges to be compulsorily questioned, and we know that that's an extraordinary power that does infringe the right to silence, and so it's a matter of balancing. We don't say that that all information needs to be disclosed, but sufficient information so that they're properly able, any lawyers properly able to represent their clients' interests is necessary.
So just in terms of the question of balance then,
Yes.
we are talking obviously about ASIO, national security and warrants. it doesn't really probably get much more serious than that. So when you talk about balance in terms of lawyers receiving more information, and you do say around the grounds for questioning a warrant, but reconciling this with, given what we are talking about, the protection of sources, the methodologies, but in particular, foreign intelligence relationships, and let's face it, foreign intelligence relationships have saved the lives of Australians in previous, examples of where terrorist threats have actually been thwarted before they've carried out the activity. How do you determine the balance?
By trying to provide sufficient information to understand the basis for the warrant without significantly threatening national security. This is these are the challenges of dealing with this sort of information, and your point is well made. But the legislation provides for legal representation, and that can only be of any use where the lawyer has an understanding of what's happening, and that's probably our submission was balanced in that we spoke about when that information would be provided. And could be provided on their attending to assist their client. And also, this is a lawyer that's going to sit through the questioning, Senator. So there is going to they're going to have a degree of understanding of what the client's being questioned about anyway. They need to know enough to be able to assist them through that process.
Just one final question then, because the Chair's been very kind to me, particularly given the lack of adverse public reporting about the fashion in which this legislation has operated in Australia in the past. What practical evidence supports the Law Society of Australia's claim that the current safeguards are inadequate?
It's the way you framed your question, Senator, shows the challenge in this area. In asking civil society to present the evidence of why things are necessary, when so much of the relevant information isn't available to civil society, is the challenge. What we're working on is best principles and drawing on other legislative examples of how safeguards are there to protect human rights, and drawing on those examples rather than being able to point to particular breaches. So we're at a disadvantage. It's to an extent somewhat unfair to call for evidence of misuse when for good reason all the evidence and all the information is not available to civil society.
Well, I think it's a little unfair then for the Law Society to perhaps criticise and say the current safeguards are inadequate, but then to say, but we have absolutely no practical evidence to support it. But Chair, I've had my questioning.
Okay, thank you. Now, Ms. Clayton has, I think, a couple of questions, and then we'll have to wrap up.
I do, and I'm very conscious that I've got like 4 minutes. So
That's okay.
We'll see how we go. But anyway, I'll try. I just wanted to ask, firstly, thank you for your evidence this morning. It's always appreciated. You both in your submission and your oral presentation this morning has argued that the compulsory questioning powers shouldn't be made permanent, and that ASIO, should be required to regularly demonstrate the continued necessity and proportionality of the powers. So just noting that the bill before us contains an amendment that allows this committee to conduct a further statutory review in 3 years. Wondering what you see as the value of retaining the sunset clause.
I think that the sunset clause does two things. So one thing is that it locks in that need for oversight. We know when it's coming, we know it's going to happen, and we know that it's going to be independent in the sense that you're engaging Parliament and you're engaging this committee, and through that civil society and the public. So that's one thing. And yes, that could be achieved by locking in a statutory way that wasn't a sunset clause, that it will have regular independent review, whether it's by this committee or by the independent monitor. The other thing that the sunset clause does, though, which has been an aim of this legislation and part of its fabric since it was first introduced, is that it really signals the extraordinary nature of this legislation. So Australia has been an outlier in thinking about these additional powers for our domestic intelligence agency since 2002 when we came up with this. These are really extraordinary powers. And just signalling that by going, it's not the kind of thing we will probably always need. We will hopefully always need. There will come a time, we hope, that we can allow these laws to sunset and rely on regular and law enforcement mechanisms, etc. So there's two things there that a sunset clause does, I think, better than regular review. But if we did lose the sunset clause, as we say in our submission, then we would very strongly support that as locked in as possible, regular review.
Thank you. And I just want to pick up, because your submission does describe these, this proposed broadening of the questioning powers to all elements of the security as an extraordinary further expansion, is your submission queries the ever-growing normalisation of extraordinary powers. So there are two arguments you're putting here. And I just want to know, why shouldn't questioning powers be available in relation to all elements of ASIO's definition of security, like its other warranted powers
are? Because they need to be necessary, and they need. This is there are a lot of powers that currently reside with ASIO that are sufficient, and that's clearly shown by the lack of use of the questioning powers. We've got this narrower, more clearly specified purpose in terms of the heads of power at the moment, and there hasn't been a warrant issued since 2022, which is indicating that a lack of necessity. And the idea of expanding when to other heads that overlap and may be covered by the existing heads in many instances at the moment is not warranted with respect, or at least not justified on the material that's available.
Just to add to that point, going to your question of why shouldn't these powers be extended, I think it ought to be flipped around as to asking why they should. And that's, I think, underlying our submissions around the need for justification, and what Mr. Babb said, that we haven't opposed expansions of these powers in the past where they have been significantly justified. We don't think that's happened in this case, with particular reference to border integrity, where we think that there has been a significant reversal in perspectives from the department and ASIO from only 12 months ago in that regard.
Sorry. Thank you. And I'll just try and squeeze a final question, if I may, because the Minister's asked this committee to consider the legislative thresholds applying to ASIO's questioning framework, including whether there should be a statutory requirement to assess necessity and proportionality in the Attorney General's issuing criteria. So would you support such a test, and why or why not?
Yes, we would strongly support such a test. It's really a glaring omission at the moment that necessity and proportionality don't form part of the test. That is best practice. When you're going to infringe human rights, then you should only do so when it's necessary, and you should only do so to the extent that it's proportionate to the threat involved. And what we've recommended in our submission are changes and legislative criteria that could guide that decision making. And it's important that it be in the legislation so that the right factors are taken into account.
Thank you, and I really appreciate the succinct response. I managed to get through all those in almost record time, Chair, for you.
Well done. Good to see we contain within 6-minute blocks. Now, on that note, thank you very much for your attendance today. If you've been asked any questions on notice, please provide that in the time frame that's requested. No doubt the Secretary will be in contact with you, and we'll also send you a copy of the transcript of your evidence today. Thank you very much, and we'll now suspend very briefly and get ready with our next lot of witnesses at 11:30. Thank you.
Thank you.
Thank you.
Joe.
Thank you.
Welcome representatives of Liberty Victoria, New South Wales Council for Civil Liberties to give evidence at this public hearing today. For the Hansard record, could I ask that you all state your full names, the capacity in which you appear today? We'll start with you, Michael.
My name's Michael Stanton. I'm the Senior Vice President of Liberty Victoria.
Isabel.
My name is Isabel Skaburskis, and I'm on the Committee of Liberty Victoria.
Now, have we got Stephen Blanks there, or have we lost him? I think we may have lost him. That's right. I'm sure the Secretariat will try and make contact with him in the meantime. In the meantime, although the committee does not require you to give evidence under oath, I should advise that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of their respective houses. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Now, I'd like to invite you to make a brief opening statement if you have one.
Thank you, Chair. I will keep this brief.
Before you do that, Michael, I just noticed that
Yes.
Stephen's back online. Stephen, hello. Can you please, for the Hansard record, state your full name and the capacity in which you appear today?
Yes, Stephen Blanks, and I appear as a member of the Executive Committee of the New South Wales Council for Civil Liberties. And sorry, I was unable to unmute before, but I can now.
It happens. This happens in this world that we live in now with virtual technology. I've just asked Mr. Stanton to provide an opening statement.
Yes.
Thank you, Chair. We'd just like to begin by acknowledging the traditional custodians of the lands where we're logging in from today, the Wurundjeri people of the Kulin Nation, and pay our respects to their elders past and present, and to pay our respects to any First Nations peoples joining us today. And we acknowledge that sovereignty was never ceded. Just very briefly, Liberty Victoria, or the Victorian Council for Civil Liberties, has worked to defend and extend human rights and freedoms in Victoria for more than 80 years. Over the years, we've had executive committee members from across the political spectrum, including the Honourable Gareth Evans and the late Alan Misson, Liberal Senator for Victoria. We're a frequent contributor to federal and state committees of inquiry, and we campaign extensively for the better protection of civil liberties and human rights in the community. In relation to the bill, at the outset, we acknowledge the important and vital work that ASIO does, and we acknowledge that ASIO has to be able to respond to the real and significant threats that we face in an agile manner. We are, of course, concerned by the rising national terrorism threat level, now at probable. We've also spoken out as an organisation over many years now about the rising threat of politically motivated violence, including the concerning rise of neo-Nazism. However, in our view, we should not lose sight of how extraordinary the compulsory questioning powers in Division 3 of Part 3 of the ASIO Act are. They challenge deeply held and what are fundamentally conservative rule of law principles. In many cases, if not most cases, there's no judicial oversight of the process. There's no right to silence. There's no privilege against self-incrimination, what the High Court has described as the companion principle. While there is a direct use immunity in criminal prosecutions, there's no derivative use immunity. What this means is that people can be effectively compelled to give evidence that can be used in their own prosecution in an indirect manner. The powers, of course, as we know, can be, although, as we understand, haven't been used in relation to children, and there's a very limited right to legal representation. We understand, of course, the history that these powers were first enacted after September 11, 2001, and in truly extraordinary circumstances. But we do echo the observations of Professor George Williams in relation to these powers, where he wrote an important article 10 years on from those powers, the suites of powers being enacted, where he wrote that Australia's anti-terror laws will seemingly be retained for the longer term has important implications. It means that such laws cannot be cast as a short-term aberration within the Australian legal system. Instead, they must be assessed on the basis that they alter the way in which the legal system itself is understood. Such laws create new precedents, understandings, expectations, and political conventions when it comes to the proper limits of government power and the role of the state in protecting human rights. Hence, despite their often exceptional nature, anti-terror measures are increasingly seen as normal rather than exceptional. This is due both to the passage of time and the fact that anti-terror strategies are now being copied in other areas of law. As the committee would be aware, it's previously been recommended by the Insulam as part of the Giles review that these powers be abolished or at least be allowed to lapse. But now this bill would see those powers expanded. The repeal of sunsetting provisions, which we oppose, the expansion of new categories of heads of security, including to the promotion of communal violence and the protection of Australia's border integrity. We agree with the Law Council of Australia that this would constitute a profound shift in relation to these extraordinary powers. We emphasise the fundamental importance of judicial oversight when it comes to extraordinary powers being granted to the executive when these powers are meant to be measures of last resort. We support the LCA's double lock proposal in relation to ensuring that there is judicial oversight, and we adopt their submissions in relation to legal representation and the prescribed authority provisions. In short, and this is the final point by way of opening, we are concerned that there is a danger of politicisation. And whilst, of course, we're very fortunate in Australia not to have encountered that kind of politicisation of our security agencies, one doesn't need to look very far abroad to see that there is always a danger of potential politicisation and how extraordinary powers can potentially be abused. And in Australia, we do have an example of where compulsory examination powers have been misused, and that's not through ASIO, but we do have the case of Strickland, a pseudonym, and others against the Commonwealth Director of Public Prosecution and others, 2018, volume 266, Commonwealth Law Reports 325, where the High Court had to consider the use of these extraordinary compulsory examination powers held by the ACC by the AFP. And there was a significant abuse of those powers in that case, which led ultimately to the criminal prosecutions being permanently stayed. So whilst that's no reflection on ASIO, we can't be so naive as to think that extraordinary powers can't potentially be susceptible to misuse.
Thank you for that. Now, given that I'm assuming that no other opening statements, Mr. Blanks.
Yes, if I could just make a couple of points. Firstly, ASIO's description of the current and predicted threat environment and the fact that it is dynamic does not address the value of the compulsory questioning framework that is under consideration in this review. It is background information, but that's all it is. It's important to understand that ASIO's powers are not required to deal with criminal conduct. There are other agencies that deal with criminal conduct. And when you look at ASIO's submission to this inquiry, much of the threat that it talks about is the subject of criminal law. And so a lot of what it says is not directed to the need for these questioning powers for things which could be addressed through criminal investigations. The potential extension of these powers, as other submitters have said, which were introduced as temporary extraordinary powers for in the response to the threat of mass terrorism events, to make these powers permanent powers in respect of all national security issues just shows the danger of how powers given to the executive branch of government can be slowly and gradually expanded in ways that ultimately detracts from the freedoms and the quality of the free society which we are supposed to be upholding. The information on the lack of use of these powers can be found from the annual reports of ASIO. The information is available for the period 2016 through to 2024, and it shows that the powers were used 3 times in the year 2020 to 2021 and once in the year 2021 to 2022. So 4 uses in almost a decade. That demonstrates that these powers are not critical to ASIO exercising its functions. One of the problems for civil society in addressing the issues here is because we don't know and will never know what those on those 4 occasions, what the powers are used for and what benefit ASIO derived from the use of those powers, if any, we're not able to make any assessment of whether they were used in a way that was really unique and justified by the circumstances. So, and finally, in relation to making these powers permanent, the fact that these powers are temporary and subject to regular review and justification is itself an important protection against the potential for abuse of these extraordinary powers.
All right, thanks, Mr. Blanks. I'll now hand the call over to Senator Cash.
Thank you very much, and thank you for your submissions. I will also have a number of questions, given I have 10 minutes, that I'll put on notice. Much of your submission is based on the Independent National Security Legislation Monitor's 2016 conclusions. These, however, were written before developments like, for example, the Ukraine and Middle East conflicts, the acceleration of violent online radicalisation, rise of much state-based foreign interference, and recent hostile state sabotage attempts globally and here domestically. Do you not accept that contemporary threat activity and intelligence should outweigh a single, now 9-year-old assessment?
Thank you for the question, Senator. One can accept ASIO's statement that the security environment is presenting an unprecedented number of challenges across ASIO's heads of security and an unprecedented level of cumulative harm, but that does not in itself address why these powers are required given their infrequent use. Go back to 2016, and in 2016 we were at the height of the ISIS crisis and the war in Syria, and at the time one could well have understood there never to have been a greater threat to Australia's national security than that crisis threw up, when what was going on was the active recruitment of Australians to participate on ISIS's side in that horrible conflict. So ASIO at that time was facing serious national security threats. True it is that the threats now may be of a different character, but we have, over the last 20 years, lived through serious threats. One can't use the argument to say, well, there's always serious threats, therefore extraordinary powers which undermine democratic freedoms are justified.
Thank you.
Anyone else want to add?
Can I'll
agree.
move. I was happy with that answer. So, I think you've answered the question. I've got so many questions. Now, your submission asserts a number of times that innocent people can be compelled for questioning. Isn't the very point, though, of intelligence gathering to proactively try to mitigate danger and to identify a person, persons and or a group or groups' potential involvement in a very serious crime before the crime actually occurs?
The powers in relation to threatened crimes exist in other organisations, and it's not demonstrated that these powers have been used for that purpose or are required for that purpose.
Which then takes me to my next question then. You claim the politically motivated violence definition is nebulous and could even capture activity to protest, march or rally. Can you provide the Senate committee with a list of examples where ASIO has ever used compulsory questioning against peaceful protesters?
Well, that information is not in the public domain.
Well, so the answer is no then. You also suggest in point 6C of your submission that politically motivated violence merely requires an act like, and I'll quote here, throwing a punch at a protest, close quote. How do you say this meets the threshold of the statutory definition when it actually involves serious violence or threats to the safety of the Commonwealth?
Well, the statutory definition of terrorism is currently under review by the Insulam. But one of the concerns...
The statutory definition is serious violence or threats to the safety of the Commonwealth. So how does an act like throwing a punch at a protest meet that? I'm genuinely interested in this, meet the statutory definition.
That particular example may not, but that doesn't really go to the point.
I'm a little confused then. You cite an example.
What if... So the Nazi rally in Sydney last weekend.
Yes.
What if the Nazi rally, instead of being in Sydney, had been in Canberra, and there had been an altercation between the neo-Nazis there and the AFP? That would be within the definition?
Chair, am I able to keep going? Sorry, I've hit the 10 minutes, I think.
Yes, that's all right. Just a few more minutes. That's all right.
Okay, gentlemen, I will keep moving because I've got so many questions I'll be putting on notice. In point 6 of the submission in particular, you express concerns about the reasonable in all the circumstances requirement, but that is actually a standard used, as you would know, throughout Commonwealth legislation. So is it your position that ASIO should uniquely be held to a higher threshold than other organisations, including every other national security and law enforcement agency? And if so, why? I just want to clarify that.
The answer is... No, sorry, I'll defer to Michael. Michael can answer that.
Thanks, Senator. Our concern is whenever you have an executive body, whether it's ASIO or the Australian Crime Commission, that has extraordinary powers, there is a real challenge when it comes to civil society, understanding whether those powers are being exercised reasonably, proportionately and appropriately. And in a way, we have one arm tied behind our back because we don't know all the facts. And of course, we believe that the vast majority, if not all people employed by ASIO, are trying to do their best in our national interests. But our concern is that when you have such extraordinary powers without judicial oversight, so without oversight of the independent umpire, which is such a fundamental part of the separation of powers, that fundamental conservative rule of law principle, that there is the potential for abuse. And we want to guard against the worst case scenario by only having these extraordinary powers when they are absolutely necessary, and when these powers haven't been asked for previously, despite 20 years plus of incredibly challenging national security environment, a very challenging national security environment, accepting it's now more diffuse and there are other unique challenges, then there should be a fair degree of healthy scepticism in determining whether or not these are actually necessary and justifiable.
No, and I appreciate that. So can I just confirm then, given it's a standard use throughout Commonwealth legislation, are you arguing that we take that view in relation to all of the Commonwealth legislation, that reasonable in all the circumstances is utilised, or is it this legislation and the fact that it is ASIO and they potentially should be held to a higher threshold?
Where any executive agency that doesn't have oversight from the independent judicial arm of government, in our view, should be held to a particularly high standard, and any granting of additional powers should be scrutinised with the utmost care in our view. And that one of the issues, of course, as you know, Senator, is that it's not as though these powers can be
Just one more question, and then I'll put the rest on notice. But it's a very interesting point you make. You cite, and you stated it, the limited use of questioning warrants. I think you said it was approximately 20 and 20 years, as evidence the powers are potentially unnecessary. Could I put to you, wouldn't the opposite actually be true, that careful, targeted use demonstrates restraint and proportionality?
That's certainly open, Senator, to look at the use of those powers and to reach a conclusion. We, of course, don't have the information to test that hypothesis, but to say, well, this shows that these powers are being used carefully. And one would hope that that is how they'll continue to be used. But there are examples, and as I said at the outset, it wasn't ASIO that was engaged in this, but there are examples of compulsory powers of examination that have been misused, where there have been some serious breaches in relation to fundamental fair trial rights. And whilst we, of course, trust those employed by ASIO are doing their very best for our national security, it takes one rogue agent, one bad actor in the future with these extraordinary powers, and suddenly people could find themselves in a very, very unfortunate situation with the trampling of their fair trial rights. And we can't really know necessarily at the moment how information that's been derived from these processes have potentially been used in investigations of criminal offences, because, as you know, Senator, there's a direct use immunity, but there's no derivative use immunity in relation to material that's obtained through these processes. So it's potentially the case that this material has informed prosecutions and then hasn't potentially been disclosed to the defence or even the prosecution by police investigating matters because of public interest immunity. So echoing the Law Council of Australia's submission this morning, it puts us in a very difficult position without having that transparency to be able to understand exactly how these powers are being used. But what we can say is that where there's extraordinary powers, there is the potential, unless there's really tight oversight, and that's why a sunset clause is so important, there is the potential for misuse in the future. And we can hope for the best, but we should always be prepared for the worst.
Thank you very much.
If I can just add to that very briefly, it may well be that the existence of the sunset clause is a factor in ensuring that the power is used judiciously. And the removal of the sunset clause could result in a change in the way in which the power is used.
All right, now, Ms. Clayton, I think you've got one or two very quick questions, and then we'll conclude.
Thank you, Chair, and thank you to the three witnesses today. Really appreciate your time and the submission provided to the committee. I'll try and just ask two questions fairly swiftly, as important as they are, but your submission describes the questioning warrants as a form of administrative detention. That's unacceptable in a democratic society. I think that's where your submission lies. So I'd like to know if you consider if there are any circumstances where it would be acceptable for ASIO to require a person to answer questions in relation to security threats?
The answer is no. We advocate the repeal of these powers for the reasons set out in the Insulum's report from 2016.
Okay. Then can I go to my next question, which is really that the ministers asked this committee to consider the legislative thresholds applying to ASIO's questioning framework, including whether there should be a statutory requirement to assess necessity and proportionality in the Attorney General's issuing criterion. I'm just wondering if you would support such a test and why or why not?
Michael?
Absolutely. Yes, we would support that. It's so important to have a threshold of necessity and proportionality with these extraordinary powers. The reality, of course, is that one might have an objection to the laws in toto, but the reality, of course, is at minimum, they'll be retained in their current state. The real question is, should they be expanded at a pragmatic level? Should they be expanded to these new categories? And what should the protections be? And when it comes to the reality of the situation, in our view, there should be considerations of necessity and absolutely proportionality should be considered. And that would be, one could imagine, particularly important when it came to the potential for children witnesses, whether when it comes to that particular vulnerability of children. And we know that those powers have not been exercised, as we understand it, against children. But if there is to be use of those powers in relation to children, one would think that a proportionality analysis would have real work to do in those kinds of cases.
I thank you for your very succinct answers and appreciate the time constraints that we're in. Over to you, Chair.
All right, thanks a lot for being so succinct on that, Ms. Clayton, and witnesses. On that note, I just want to say thank you to all our witnesses this morning. If you've been asked to provide any additional information, could you please provide that to the Secretariat within the time frame requested, and we'll ensure to get you a copy of the transcript from today. Now, on that note, we're going to suspend for 30 minutes and be back with our next lot of witnesses. Thanks, everyone. See you here
Thank you,
in
Chair.
30 minutes' time.
Thank you, Chair.
Thank you. Cheers.
again, thank you. I'd like to now welcome Mr. Chris Taylor, Australian Strategic Policy Institute, to give evidence at today's public hearing. For the Hansard record, could you please state your full name and the capacity in which you appear before today's hearing?
Thank you, Chair. My name is Chris Taylor. I'm the head of the Statecraft and Intelligence Policy Centre at the Australian Strategic Policy Institute.
Although the committee does not require you to give evidence under oath, I should advise that this hearing is a legal proceeding of the Parliament and therefore has the same standings as proceedings of their respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Now, I'd like to invite you to make a brief opening statement if you have one, Mr. Taylor.
Thank you, Chair. Yes, I do. I welcome the opportunity to answer questions on the ASIO Amendment Bill number 2 and to add to my written submission to the committee's review of the bill. At the outset, I should note that my evidence today and my written submission are made as an individual. While I do so in my professional capacity as head of the Statecraft and Intelligence Policy Centre at the Australian Strategic Policy Institute, it's important to clarify that ASPI does not itself have institutional positions, including on this bill. In addition, and for context, my evidence and submission are made based on my professional experience and judgment in relation to national security policy and operational matters. There are many others from within and outside government who will be giving evidence to the committee from a legal and constitutional perspective. I trust that my contribution, focused on the national security dimensions of the legislation in question, will be of complementary utility. In that regard, I note that ASPI's Statecraft and Intelligence Policy Centre has now been in existence for almost 3 years and remains unique in Australia as a research centre focused on national intelligence matters. In addition to commentary, the centre has published well-received research into issues such as the independent intelligence review process, intelligence diplomacy, innovation within the national intelligence community, strategic warning, and indeed the future of parliamentary oversight of the national intelligence community. With regard to the bill under consideration, per my submission, I endorse the bill and its purpose. In my view, the bill presents 2 questions to the committee. Should ASIO's compulsory questioning powers be made permanent, and should application of those powers be extended beyond politically motivated violence and espionage and foreign interference to the full range of threats to security covered by the ASIO Act? And in my view, the answer to both questions should be in the affirmative. On the question of permanence, I think it's most accurate to state that the bill will allow us to move beyond the misnomer that these measures, which have been continuously operative in Australian law for 22 years, are somehow temporary. This is not to downplay the extraordinary nature of the powers. Indeed, I agree fully with the proposition that ASIO's compulsory questioning powers are extraordinary powers and laws. But whereas that assessment of their extraordinary character leads other submission authors to oppose the bill, I argue that the extraordinary character of the powers is in fact the reason why the bill is so important and worthy of support. Since the introduction of the powers in 2003, Parliament has voted on 6 separate occasions to extend their life, including as recently as 2 months ago. Laws with the power to compel the attendance of citizens and withhold their right to silence should be treated with deadly seriousness, and that means not pretending they're somehow provisional. It's my view that rather than continue to so pretend, the Parliament's focus should instead be on the proper operation and application of the powers by ASIO, the AFP and the rest of government. Subsequent to the scheduled PJCIS review in 3 years' time, and without prejudging that review's outcome, the soon-to-be further empowered Independent National Security Legislation Monitor is best placed to address the question of the enduring relevance of the powers. Furthermore, in my view, the security environment confronting Australia requires ASIO's compulsory questioning powers to be on the statute books for use in extraordinary circumstances where other avenues for intelligence gathering have been exhausted, and hence applied with the same parsimony apparent from the granting of just 20 warrants in over 2 decades. On the question of extension, the first principles debate on whether these powers should be limited only to counter-terrorism efforts was settled when they were applied to countering espionage and foreign interference 5 years ago. There is no logical difference between application of the powers in those circumstances and their application to sabotage, for instance. In fact, I'd argue there is a particularly strong case for application to sabotage, as well as to communal violence, given the well-documented upsurge in the use of sabotage as a tool of international statecraft, most notably in Europe and the Middle East. With the committee's indulgence, I also wish to make a correction regarding detention warrants. In referring to historic detention warrants in my submission, I might have given the incorrect impression that those particular warrants remain extant. As you know, unlike questioning warrants, detention warrants are no longer available following passage of the ASIO Amendment Act 2020. Finally, I should note that while this is a case of extraordinary powers for use in extraordinary circumstances, I don't share the view that these are extraordinary times. Framing the security environment now, and at the time of the powers introduction in those terms, contributes to the obfuscation around the powers. Like very many others, I've been guilty in the past of such rhetorical flourishes as for the first time since the Second World War, etc. When in fact, and on reflection, I'm increasingly of the view that the extraordinary times were in fact the momentary respite afforded to Australia by our relative prosperity and geographic and cognitive distance from war, disorder and threat from as recently as the end of confrontation until the turn of the century. What has been experienced since then, punctuated by Timor, 9/11, Bali, etc., is in fact the new normal, and we should expect our relative security and prosperity to be tested continuously in the decades to come. In those, unfortunately, thoroughly ordinary times, ASIO's compulsory questioning powers, genuinely extraordinary powers for use in extraordinary circumstances, will be a valuable national security tool. Thank you.
Thanks a lot, Mr. Taylor. Now, I've got a few questions I'd like to ask you before I hand the call over to Senator Cash. What's your view on the removal of the sunsetting provisions contained within the bill?
So I support the removal of the sunset provisions on the basis that the Parliament has voted on numerous occasions for the extension of the powers. I think it is unfair to regard them as temporary. They are a part of Australian national security law. I think that the suggestion that they are temporary gives some kind of potential diversion of attention towards that issue of the sunsetting rather than towards the operation of the powers and the conduct of ASIO, the police and others in relation to them.
Do you think the sunset provisions is an oversight measure?
So I was interested in a point that was raised earlier about suggesting that the sunset provisions might in some way have contributed, for example, to the limited use of the powers over the course of the last 22 years. I'm not sure I support that proposition. I can't see the necessary connection between those two things.
Could you explain what you mean when you say that just because the powers have only been used sparingly does not invalidate them or make them redundant?
Indeed, and I think there's a common refrain about the powers that suggests that because they have been used in such limited circumstances, and indeed in a rather lumpy fashion too, they haven't been used in a consistent fashion across the 22 years, that this in some way reflects a suggestion that they are unneeded or not critical to the performance of ASIO's functions. I think instead that their use to date has been in accordance with the way that they were framed when they were introduced in 2003. That is, that they're framed as essentially an intelligence gathering action of last resort, that they are always intended to be unusual and used only in circumstances where all other means of intelligence gathering, and ASIO has a wide range of tools available through which to collect intelligence about threats to security, whether that's the overt relationships that ASIO has with the community more broadly, whether that's ASIO's covert collection capabilities, both human and technical. When those are exhausted, and only in circumstances and when they're exhausted, is there recourse to these particular powers. And to me, that sounds reasonable. That to me reflects what was intended by the Parliament when first introducing those laws.
Yeah. And I suspect also there'd be any oversight or issues, then the IGES would be able to have oversight over how these agencies would actually be using such measures, correct?
Indeed, and I think your point about IGES is quite correct. In some of these discussions, perhaps because we're focused around issues like sunsetting, the ability that IGES has, not only in terms of oversight of the intelligence agencies, including ASIO, but oversight of matters in relation to the questioning powers, I think is overlooked. I'm particularly taken, for example, by the late Margaret Stone's 2017 submission, an account essentially of the use of the powers. and the experiences of IGAS and their staff in observing compulsory questioning, including quite early in the life of those powers. Given that there is, and it is reasonable to note that there is limited public information about the actual exercise of the powers, I'm actually quite buoyed by, for example, that particular submission that was written in 2017.
And I think also the fact that there's an amendment to allow this committee to conduct a further statutory review in 3 years.
Indeed, and I think that's entirely appropriate. And I would, as per my opening statement, I would suggest that the soon-to-be newly empowered INSLM, in the wake of the Sonic Bill, but also in terms of the enhancements to the role of the INSLM that have come from having a full-time INSLM whose day job is the review of national security legislation, who has staff, who has, in the case of the current incumbent, extensive knowledge of national security law. All those things make the INSLM particularly well positioned in the future, indeed beyond the 3-year review by the PJCIS, to make sure that these laws continue to be relevant in the absence of a sunsetting provision.
And what's your view on aligning the scope of the powers with ASIO's heads of security and how it relates to the current threat environment?
So I think it is reflective of the current threat environment. And as I mentioned, I in contemplating a kind of first principles question of whether these powers should be extended beyond countering terrorism, and often these laws, indeed many national security laws, are framed in that way. They're framed as counter-terrorism measures even when they have a much broader application. Given the decision of the Parliament in 2020 to extend the powers beyond politically motivated violence to espionage and foreign interference, I actually think there's a logical progression, given the current security environment, to the other heads of security. As I mentioned, I'm particularly taken, and I note the public statements made by the Director General of ASIO over the course of the last fortnight, but also in terms of the public record of the upsurge in the use of sabotage as, unfortunately, an increasingly normal part of the way that particularly certain states conduct themselves. And I note that particularly in relation to the activities of Russian intelligence services in Europe and their use of criminal proxies, particularly in the wake of the degradation of their own capabilities that came from expulsions of Russian intelligence officers after 2018 and then again after 2022. They have sought to rely on criminal proxies to undertake sabotage, and a number of those instances of sabotage have had the potential to cause extraordinary harm. Most particularly, I note what appeared to be a test run against DHL freight systems in Europe that had the potential to bring down airliners. All of those things point to a deepening and broadening level of threat across the heads of security. And as I say, I think there is a logic in their application to those other heads of security. And I include within that territorial and border integrity, which I think can sometimes be necessarily overlooked because it is, in a sense, a latecomer to the ASIO heads of security, having been introduced only in 2010. But to my mind, that actually touches on some really acute national interests and has an interface with questions around social cohesion as well. So in my view, the extension to all of the heads of security is an appropriate one.
Oh, and just lastly, do you think there are appropriate safeguards, oversight and governance for these powers that have been contained within the bill?
So I think that it's appropriate for there to be a in the event that the Parliament decides to pass this bill, and particularly it's no longer subject to the sunsetting provisions. I think it's appropriate to turn to the questions of their operation and their conduct. And I think it's entirely fair to ask questions about the degree to which there should be, potentially more information imparted by ASIO about their use. And I think that would be of a piece with, again, an increase on the part of ASIO in being more open about their responsibilities, their roles and their conduct, without necessarily betraying the effective use of those powers. So I think there is an opportunity, after the bill is passed, or should the bill be passed, I should say, in order for there to be a renewed focus on those elements, and indeed, to hark back to the previous answer, an emphasis on the role of IGAS in overseeing the actual conduct of these kinds of questioning arrangements.
All right, thanks, Mr. Taylor. Now, Senator Cash, you have the call.
Thank you, Chair. And I have to say, you took the words right out of my mouth for the first question you asked, so that was good. My second question, therefore, is you emphasise that these are extraordinary powers for extraordinary circumstances. Can you expand on what sort of circumstances would make compulsory questioning the only viable intelligence option?
Thank you, Senator. I think it is a question of the exhaustion of other avenues of intelligence gathering in relation to these kind of security threats. So, as I noted, ASIO does have a wide-ranging toolkit when it comes to the collection of intelligence in order to undertake investigations and assessments. That ranges from the relationships that it has with the community in the broad, as well as specific communities, right through human and technical intelligence collection. And I think there are circumstances, as has been the case over the course of the last 2 decades, where in relation to threats that are viewed particularly acutely, where there has been an exhaustion of those other intelligence gathering opportunities, and therefore a reliance on this as a critical last resort, I think, as it was phrased in the second reading speech when these were introduced in 2003.
Yeah, no, thank you for that. The bill also narrows who may act as a prescribed authority. Can I just ask, in your opinion, how does this adjustment strengthen the integrity of the questioning process?
I mean, I think the role of the prescribed authorities is particularly important in ensuring the appropriate conduct of this questioning. I think that you could take the view that much of the change in relation to the prescribed authorities is a matter of perception, by excluding several categories of people from being able to be a prescribed authority, and I think that's appropriate, even if that is essentially a kind of belt and braces approach, and one that is based principally around the question of perception of how those prescribed authorities work.
Okay, just going back to the previous witnesses we heard from this morning, who didn't necessarily support what this bill was proposing to do. If I look at sort of what you have stated, so you conclude that the bill is an appropriate and proportionate enhancement of ASIO's tools, but do you accept any of the positions and arguments, in particular, say, from the civil liberty groups and even from the Law Society of Australia, that compulsory questioning powers in the way that they are currently legislated and in the way that they are proposed to be revised through this bill impinge on personal rights and freedoms?
So I'm loath to necessarily direct particular commentary on other witnesses before the inquiry, but I would note that I think I share the idea that was put by those previous witnesses that these are indeed extraordinary. The nature of compelling a person to appear in a particular place, to undergo questioning, and to void a right to silence is extraordinary. And that they are, as I've mentioned, very much as a matter of last resort in terms of intelligence gathering. I think I just take a different view in terms of the appropriateness of having those kind of laws essentially on the shelf for this kind of use in these kind of circumstances. I take a position that it is appropriate to have as a contingency national security laws that are intended to apply in circumstances of extremis, rather than having a circumstance in which the Parliament is then asked to essentially conjure up new laws in response to threats as they arise.
Yeah, no. So thank you for that. And we actually almost end up back where Senator Ciccone, our chair, started. Is there anything further than you'd like to add to the line of questioning that Senator Ciccone put to you in terms of your argument that the relatively intermittent use of the powers actually strengthens rather than weakens the case for retaining them as a last resort capability, in particular in light of what other witnesses have said, which is that they do obviously, and I mean you agree with them, but it is because of the nature of what we're looking at, and I would say they do strengthen the use, they need to be strengthened, impinge on personal rights and freedoms. Is there anything else you want to add to your initial answer?
I'd simply add that I suppose this is a question of perspectives. So I come at this question from the perspective principally of national security, and as I think as a pragmatist. So I see very much the case that these have been used in such a limited fashion as evidence that they are being used proportionately and appropriately. I'm not sure how the opposite of that is, if they'd been used in a prolific fashion by ASIO, would somehow prove that to be the case, that they were being used proportionately. So the logic of the situation suggests to me that that limited use is reflective of the fact that they are being used as a measure of last resort and have been used proportionately and appropriately.
Thank you very much, and thank you very much, Chair.
Thanks, Senator Cash. Mr. Taylor, we're ahead of schedule, thank you. On that note, I think we say thank you very much to you and for the time that you've made today, including your submission to today's bill. We'll just suspend very briefly and get ready for our next lot of witnesses, being ASIO and the department. Okay, we've got everyone down. Excellent. Good afternoon. All right, we'll now recommence. I'd like to now welcome representatives from the Department of Home Affairs and the Australian Security Intelligence Organisation to give evidence at this hearing today, public hearing today. For the Hansard record, could I ask that you all state your full name and the capacity in which you appear today? And we'll start with the department.
Thanks very much, Chair. Andrew Warnes, First Assistant Secretary of the Criminal Justice Division in the Department of Home Affairs.
Parker Reeve, Assistant Secretary, Intelligence and Surveillance Policy Branch, Department of Home Affairs.
And Michael Noyes, Acting Director General, ASIO.
And who else is at the table next to you?
Oh, sorry, I'm accompanied by another ASIO officer but who's not a formal witness for the proceedings, but thank you.
That's all right. All right, well, thank you very much. Now, although the committee does not require you to give evidence under oath, I should advise that hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of their respective houses. Giving false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Now, I just wanted to invite, do either the Department or ASIO have an opening statement they'd like to make today?
Yeah, thank you, Chair. The Department has an opening statement and ASIO has a very brief opening statement following that.
Thank you.
Thank you. I'd just like to thank you, Chair, and the committee for the opportunity to appear today, and particularly the opportunity to appear together. I think it's quite useful to have both the department and the agency in question appearing together. Hopefully the committee finds it useful as well. ASIO performs an essential role in protecting Australia and Australians from threats to their security. And the compulsory questioning powers contained in Division 3 of Part 3 of the ASIO Act provide ASIO with a unique and necessary tool to investigate the most significant threats that are confronting confronting Australia today. In his 2025 annual threat assessment, the Director General of Security made it clear that Australia's security environment is becoming more dynamic, more diverse and more degraded. Australia faces multifaceted, concurrent and cascading threats. The bill amends ASIO's compulsory questioning framework to ensure ASIO has the powers it needs to operate effectively in this aforementioned environment. It would expand the security matters for which ASIO may seek a questioning warrant to sabotage, the promotion of communal violence, attacks on Australia's defence system and serious threats to Australia's territory and border integrity. That's in addition to the three purposes which it currently has for questioning warrants, which are politically motivated violence, espionage and foreign interference. While these are among ASIO's principal concerns, the Director General of Security has stated it's becoming increasingly difficult to categorise intersecting threats. Enabling ASIO to use its questioning powers across a broader range of security threats will ensure that the powers reflect the blurring and intersecting nature of those threats as well. The bill also has strengthened safeguards. The compulsory questioning powers, it should be noted, are already subject to very robust safeguards, but the bill responds to evidence that the committee heard in 2023 inquiry into this framework, and it amends the eligibility and termination provisions for prescribed authorities to ensure independence and impartiality of persons appointed to the role, requires that post-charge questioning occur only before a prescribed authority who is a former Superior Court judge, and it introduced additional reporting requirements to ensure the Attorney-General is made aware of relevant information regarding conduct under the warrant. In terms of sunsetting, the bill would repeal the sunsetting provision and make ASIO's compulsory questioning powers permanent. I think, Chair, for over 20 years, ASIO has used these powers judiciously to obtain high-value intelligence in circumstances where ASIO's other powers have been exhausted or otherwise not appropriate. As the Home Affairs Minister stated in his second reading speech on the bill, removing the sunset provision reflects the government's view that these powers now form an essential part of ASIO's collection powers, particularly in light of the threat environment. It's really important to note that removing the sunset provision would not remove parliamentary oversight of the framework. The bill would amend the Intelligence Services Act to permit the PJSIS to undertake a further review of the framework 3 years after the commencement of the bill. I'll pause there and pass to my ASIO colleagues.
Thank you. And thank you, Chair, and thanks for the opportunity to the whole committee. ASIO's submission to the committee notes that compulsory questioning warrant powers remain a vital capability to protect Australia and Australians from threats to their security. Australia's already complex, challenging and changing security environment is becoming more dynamic, more diverse and more degraded. The security environment is presenting an unprecedented number of challenges across ASIO's heads of security and an unprecedented level of cumulative harm. This is the scale of the challenge ASIO faces as a security service and that Australia faces as a nation. It's vital that ASIO's powers enable the organisation to fulfil its mission. Compulsory questioning powers have proven valuable, yielding high-value intelligence relevant to security over the years, particularly in circumstances where ASIO's other powers were not effective. ASIO is supportive of the proposed amendments to the framework and considers that the bill includes balanced and proportionate measures to support ASIO to effectively fulfil our mission of protecting Australia and Australians from threats to security. Thank you.
Thank you. Now, I'll ask Home Affairs a few questions before I hand the call over to Senator Cash. But Home Affairs, can you just tell me and the committee what the difference is between this bill and that was introduced in the last Parliament and the rationale for the changes between the two bills?
I don't... Sorry, Chair, we're looking at each other. I'm not aware of the last bill that you're referring to.
So there were, I think, proposed changes in the last term of Parliament. And as I understand it, there were some changes that were brought forward. And I don't think this committee ever had time to look or report, but were there not reforms in the last term that were looked at by the department with respect to this ASIO number 2? Or
apologies, yes, Chair. I'll pass to Mr. Reeve, just noting that neither I or Mr. Reeve were responsible for the bill in the previous term, so our answers might be more limited, but I'll pass to Mr. Reeve.
No, thank you, Chair. Sorry for the confusion on that. So in the last term of the Parliament, this committee was conducting a statutory review of the framework under the Intelligence Services Act. There wasn't a specific bill before the committee in the course of that inquiry, but both the department and ASIO put submissions to the inquiry on both the nature of the framework as it stood at that time, as well as potential reforms to the framework at that time, as did, of course, a number of other civil society organisations. I think this bill reflects some of the issues put forward by Home Affairs in its submission, insofar as it expands the scope of the questioning warrant framework to additional heads of security, in particular to protect Australia and Australians from sabotage, attacks on the defence system and the promotion of communal violence. There is a difference in this bill in that the bill also proposes to expand the questioning warrant framework to the protection of Australia's territorial and border integrity from serious threats. The bill also picks up a number of the proposals made by civil society submitters and witnesses to the 2023 PJCIS inquiry around additional safeguards that could be included in the framework. So to further strengthen the independence and impartiality of prescribed authorities, to introduce additional reporting requirements to the Attorney-General, in particular on any non-compliance with or contravention of a questioning warrant, and to strengthen the safeguards around post-charge questioning under a questioning warrant. The other two distinctions, I think, between what was before the committee in 2023 and this bill relate to the removal of the sunset provision, which I think has been canvassed throughout evidence this morning, and the retention of questioning warrants for minors, Chair.
All right, thanks for that. So in terms of the changes, yes, it did follow on through, as you said, the stat review. And my apologies, I mean, I wasn't in the position then, so I just assumed that it was part of one of those reviews, and I should have just mentioned that. But what oversight improvements have you proposed then via this bill, having heard some of the evidence in the last Parliament?
Some safeguards.
So, Chair, I think the first set of changes that are proposed in this bill to strengthen oversight are to expand the matters that would disqualify a person from being appointed as prescribed authority. So this responds in particular to some issues raised by the Law Council of Australia in the 2023 inquiry, that there are sort of a wider range of public servants, if I can just use a broad term, who should never be appointed as prescribed authority because they would hold an inherent conflict of interest with the office they hold as a public servant and performing the role of a prescribed authority. The second set of safeguards are to strengthen and modernise the arrangements of the termination of prescribed authorities. And I should mention, Chairman, prescribed authorities perform an absolutely central role in the execution of questioning warrants. Their role is to control the conduct of the questioning by ASIO, including to deal with any issues, concerns or complaints raised by the person who is subject to questioning during the conduct of that questioning. The strengthening of the termination provisions brings them into line with the termination provisions for other independent oversight authorities, in particular to mandate their termination if they were to become bankrupt, for example, or to fail to comply with their conflict of interest avoidance obligations. The third set of safeguards that are strengthened in this bill around after-the-fact reporting to the Attorney-General, including quite explicitly a requirement for ASIO to report to the Attorney-General any non-compliance with or contravention of a questioning warrant. And then the fourth set of safeguards that are strengthened in this bill are to require that any post-charge questioning of a person under a questioning warrant, so that's questioning a person when they have been charged with a criminal offence or where such a charge is imminent, is conducted before a prescribed authority who is a former Superior Court judge. The reason being that post-charge questioning is inherently legally complex and a former Superior Court judge is the best placed to oversee such questioning. And then finally, Chair, the bill also inserts a new ability for the Parliament, this committee, to conduct a further review of the framework as a whole 3 years after the commencement of the bill.
Okay, so after the commencement of the bill. And in terms of the powers, you would have heard from earlier evidence today that, that there were some concerns because they hadn't been used or are infrequently used then while we proceed with this. But does it matter that the powers that are being proposed in the bill are used infrequently?
Yeah, thanks very much, Chair. It's a really good question, and I have to say comes up across the use of intelligence agency and law enforcement powers regularly, and I think we should be dissuaded to be attracted to the notion that there's some magical Goldilocks number that is the right number for powers to be used. The powers that are provided to intelligence and law enforcement agencies should be used when the appropriate thresholds set by Parliament are met and they're appropriate to be used. And I think with the ASIO questioning warrants, that's exactly what you've seen, where ASIO has formed the view that it has needed to utilise these powers. It has done so judiciously where it's appropriate, and that has been a limited number of times. As I would say you would expect for powers of this nature, they're not designed to be used every day. They are at the upper end of ASIO's, I dislike the word, but toolkit of powers that it can use. And therefore, I would say when you're seeing on average, I think one a year, I wouldn't make a comment about whether that's appropriate or not. What I would say is it's what ASIO has felt it has needed to do. I think if it had never been used, that always calls into question how useful it is. If it had been used thousands of times, I think there'd probably be a different conversation we're having. As I say, I'm not attracted to put a number on what's appropriate use, but I think the usage you've seen is reflective of generally appropriate usage. And the other comment that I'd make is these are robustly oversighted powers by the Inspector General of Intelligence and Security, and to my knowledge, they have never raised any serious concerns about the appropriateness of ASIO seeking the warrants that they have.
Yeah, and that was a question I asked in the earlier witness before you, which you may have been in the room for. I mean, in terms of the role that I just plays here.
Yeah, it's a fundamentally important role, and I think a few a few people appearing this morning noted the difficulty of assessing some of these things when it comes to an agency like ASIO, and I think that's why IGES is so important. It's got the powers of a standing royal commission to inspect anything, to turn up and look at things and probe every aspect of what ASIO does, and I'd leave it to the Acting Director General to comment on that oversight, but my understanding of it is it's very vigorous and robust, and I think provides a lot of assurance, hopefully, to Parliament and the broader community about the role that they do play there.
Yeah, the only thing I would add to that, and I think I've spoken to the committee before about the principle of proportionality that governs our intelligence collection, including in the context of compulsory questioning. Wherever we can, we're going to use measures that are least intrusive before we resort to a power that has the level of intrusiveness that comes with compulsory questioning. So, as you've heard from the department, the very small number reflects judicious use over many years, but on the occasions that it has been used, it's shown itself to be a very valuable tool.
And I know there was some concerns earlier today around reporting of the use of such powers. I mean, as best as you can in this setting to alleviate some of those concerns from earlier witnesses, is there anything else that you could add on the record to address the concerns that were raised or questions that were put and asked from earlier witnesses?
I think I'd be probably just repeating in different words the points that I've made. It goes to the principle of necessity and proportionality, and the fact that wherever we can, we will use less intrusive methods before we would resort to our more intrusive powers, including compulsory questioning.
Now, my last question before I hand over to Senator Cash is, why is it important that for the powers that are in the bill to be extended to ASIO's remaining heads of security, and how does it align with ASIO's threat assessment? And just direct to the department first.
Thanks very much, Chair. I'd refer back to my opening statement where you've seen very clearly from the Director General, and was referenced earlier over the last couple of weeks in terms of the threat that we're facing, and you're seeing convergent and intersecting threats, which are often hard to distinguish between whether someone is a national security actor, an organised crime actor, and making sure that you've got these really important questioning warrants available across the broad suite of ASIO security threats as those threats are becoming more diverse, more intersecting and more complex. The government sees as a really important role. Again, that doesn't mean that the expansion of these is expected to result in many, many more questioning warrants. The expectation, and I mean, I'm sure the Acting Director General can talk to this, but the expectation is that they will remain a somewhat power of last resort where it is proportionate and appropriate to use them.
Would you like me to add to that, Chair?
If you wanted to add, yeah, that'd be great. And then I'll hand the call.
Absolutely. The actual Director General, as opposed to the acting that you have today, has spoken publicly about the security environment and explained how it's becoming more dynamic, more diverse, and more degraded. On the diverse point, I'll just focus on that for a second. That's a reference to the fact that unlike other times in our history where we might have looked at almost all or a large proportion of our security threats sitting under one heading or another, we're actually seeing security threats manifest right across the spectrum of the heads of security that we're responsible to respond in respect of. So if I took each of those in turn, I'll take the first two as a pigeon pair, if you like. Sabotage and attacks on the defence system. We're seeing authoritarian states more willing now to undertake activities that may, for example, threaten sabotage to critical infrastructure or to result in detriment to our warfighting capability. The other two heads of security that the powers would now extend to include promotion of communal violence. So again, you've heard the Director-General speak publicly about growing grievance in our communities, polarisation of our communities, spreading of anti-authority sentiment. All of these things create the potential for spikes in community violence. And finally, the threat to border integrity. I would say that right now, the threat is not at a historic high, but it is an absolutely persistent and real threat, the threat to our border integrity. And if you look at the security outlook as we've described it and take into account global developments such as conflict, climate change, these are things that can drive displacement of people, which provides a potential market for people smugglers. And it's in that instance that we would envisage these powers becoming important. So for all those reasons, we support the move to push the compulsory questioning across the entirety of the heads of security.
All right. Now, Senator Cash, you have the call.
Thank you. And you actually just answered my first question, so I very much do appreciate that. Could I then ask, in the current security environment, what kinds of activities would qualify as promotion of communal violence that may trigger a questioning warrant?
Well, I suppose I would hesitate to give an explicit example of a particular individual or group, but what we're concerned about in this instance is where there might be existing tensions in the community, and it might be between racial groups, ethnic groups, religious groups, where one side of that argument sees fit to promote violence between those communities and exploit those divisions. If we had an imminent threat which could threaten public safety, we would be adopting a whole range of measures, including providing advice to law enforcement partners. But if we'd exhausted other measures and remained concerned about an imminent threat, and the way to mitigate that threat was to seek to question someone compulsorily, then it would be in that instance that we might resort to this power.
Yeah, no, and thank you for that. So just in terms of previous evidence that we'd heard this morning, but also building on the answer you just gave, to the extent that you are able to in this public hearing, are you able to outline the kinds of situations in the past, obviously not specific situations, but where compulsory questioning powers have been considered but then ultimately not used? And what are the alternatives that are employed in those circumstances?
There's been 20 occasions where we've requested warrants, and that's going right back to when the powers first came in the early 2000s. On 19 of those occasions, we proceeded to undertake questioning. So there was one instance where we deferred the questioning because we need to ensure that we have regard to any vulnerabilities that might exist in respect of a particular individual who's going to be questioned. In this instance, we determined that it would be unreasonable to proceed, and in that case, we deferred our proposed questioning and for long enough that the warrant was no longer in play, which is why we went back. So that's why there's that one instance where we didn't follow through.
Could I also then take a step back from that? So 20 cases warrant applied, 19 have proceeded to actual questioning. Prior to even that step, though, what are the alternatives that you utilise that mean you don't need to get to the questioning, in terms of you have a number of powers you can use, and it is only when those powers have not given you what you need that you then take the step to this particular warrant and the questioning that's involved?
Okay. Look, you'll understand why I'd hesitate to go into details of how we do our
Absolutely.
intelligence collection. What I could say, though, is that because they're in the Act, there are other warranted powers at our disposal to undertake collection, and these are things that have been around for some time, such as lawful intercept of communications, by way of one example.
And I understand that. Thank you. Just going back to the sunset clause, you state that removing the sunset clause does recognise the enduring value of the powers. So in what forms does ASIO propose to ensure continued regular transparency and proportionate use of the laws if the Parliament does actually agree to removing that sunset clause?
Yeah, well, I'll ask the department to come in after me on this one, but I'd state what I'd say is at a questioning warrant, in addition to ASIO, of course, and the person being questioned, there will be the prescribed authority, there will be the Inspector General of Intelligence and Security or their representative present at the time and throughout the course of the questioning. There's the opportunity for the person being questioned to have a lawyer present, and in that very, very rare circumstance where the person being questioned might be a minor, there can be an additional minor's representative present. So there's a lot of transparency that goes into the process there. In addition, and this was referenced earlier, ASIO needs to provide the Attorney General a report after the questioning's taken place that will include commentary on the intelligence value, the time that the duration of the questioning took place, and other matters. And so I think there's quite a high degree of transparency. The final point I'd make is that the number of compulsory questioning warrants that are conducted must be reported annually in our unclassified annual report.
Thank you very much for that.
Senator Cash, just the only thing I would add to that, the extensive things that the Acting Director General set out there is obviously the government's acknowledged that the Parliament will remain interested in these powers and so has added in that 3-year review post-commencement as well.
Yeah. Oh, okay, yeah, of course. Thank you very much. Just a final question for ASIO. To what extent does the expansion of ASIO's powers in the bill respond to specific intelligence gaps rather than being a more general precaution, going back to the conversation you were having with Senator Ciccone in terms of the more dynamic, diverse and degraded threat environment?
Yeah, good question. I would say it's actually almost entirely dependent on our broader assessments. It's not the case, for example, that we have a particular investigation on foot or a particular intelligence gap that we're seeking to close through the passage of this legislation. It's more that we're looking over the horizon and wanting to ensure that we have the powers that are available to us that will enable us to mitigate security threats into the future.
Yes, no, understood. Okay, thank you for that. And thank you for responding to the questions. Just for the department, and again, it's just in terms of getting the response from both ASIO and yourself as to what other witnesses have said this morning and in their submissions that present a different point of view to the question I'm going to ask. So the department emphasises in its submission the judicious use of ASIO's compulsory questioning since 2003. So if these powers have been used so judiciously, what evidence do you say points to the need for further expansion of them?
Thanks very much, Senator Cash. And I think that the evidence we point to is the submissions that you've seen from ASIO to this committee, which state that they, while judiciously, have been of immense intelligence value. And so that is the basis on which we say they should, A, be continued, but also B, be expanded to cover the other heads of security, as Acting Director General Noyce just said.
Okay, thank you for that. So, yeah, so very much then could go back to see the arguments put forward by ASIO. Just again for the department, the bill tightens eligibility for prescribed authorities. What specific considerations and principles guide the department in its decision-making about which roles should be excluded?
Thank you, Senator. So the expanded list of roles that are ineligible to be appointed as prescribed authority really focuses on roles that would have an inherent and irreconcilable conflict of interest were that person to also be appointed as a prescribed authority. So it focuses on persons who are currently serving in various Commonwealth, state and territory roles that would potentially intersect in any way with ASIO or with sort of a subsequent investigation or prosecution of a person who might be questioned.
Okay, yep, and I understand that then. And just again in terms of safeguards, what safeguards exist to ensure that the removal of legal representative for what is referred to as unduly disruptive conduct in the way potentially defined in this bill would be exercised fairly and transparently?
Thank you, Senator. So I think, first of all, the power to remove a lawyer for being unduly disruptive is a power that is vested in the prescribed authority, who is an independent authority appointed by the Attorney-General. They must be a former Superior Court judge, a president or legally qualified deputy president of the Administrative Review Tribunal, or a senior counsel. So we are talking people who are eminently qualified lawyers with demonstrated independence and impartiality to be appointed to any of those roles. It's not a power that's vested in ASIO or exercisable by ASIO themselves, first of all. Second of all, the statement of procedures made under the ASIO Act that applies to the compulsory questioning framework provides that the prescribed authority may warn the person, more than the lawyer, that they are being unduly disruptive and that they may be removed if they continue in that conduct. I think what's important to emphasise is that the compulsory questioning framework, like all other questioning frameworks that exist, is an investigative power. It's not a hearing. The person is not on trial, for example, in that process. The object of questioning is to obtain information which may potentially be time sensitive or time critical, depending on the matter that is under investigation. And so it is important that there be that questioning be able to be conducted in an efficient and timely manner and not be unduly disrupted, Senator.
Thank you very much, and can I thank you both for your answers to my question. And Chair, that is the extent of the questions I have.
All right, thanks a lot, Senator Cash. Just wanted to ask the ASIO, is it normal for ASIO's powers to be limited to certain heads of security?
Well, I guess it's normal for us to be constrained to the heads of security that are in the Act. In terms of distinctions between powers, I'm struggling to think of a parallel.
And just to add into that, it's the only one that I'm aware of, Senator.
Yeah, that's right. Well, I guess my follow-on was going to be, like, what advantages do you see from sort of this regime in terms of dealing with converging or cascading threats?
Yeah, well, I mean, I think it's helpful to have consistency in the way the powers are applied. So the proposed changes would actually bring compulsory questioning much more in line with the rest of our warrant powers, in the sense that we wouldn't be wondering whether we could use them for this power or for that power, with the very narrow exception that the politically motivated violence power is the only one under which we would be able to question people between the age of 14 to 17 inclusive.
And in terms of removing the sunset provisions, I know you touched on some questions earlier from Senator Cash, but I wanted to ask you, would it make it more comparable to ASIO's other warranted powers?
Yes.
Yeah.
Correct, Chair.
And in terms of minors, can you tell me more about the minors' caseload that features in ASIO's work and how that's changed over time?
Yes. It does oscillate around a bit, and so we really gave this quite careful consideration in our most recent submission. If you look at the cases of, if we look at the cases that plots that we disrupted in 2024, as well as actual attacks that occurred in Australia, minors were regrettably present or connected in all cases. And certainly this was the online radicalisation of minors and the heavy prevalence of minors in our casework were things that contributed, not solely responsible for, but contributed to the raising of the national threat level to probable in 2024.
And in terms of that blurred threat environment and what it means, the value of these powers to ASIO and how it helps ASIO's role and functions?
Yeah, so I don't, sorry, is the question still in relation to minors or more in terms of the blurring of boundaries between different heads of security? Sorry.
Look, my initial question does go to minors, but then I will also ask you to elaborate on the more broader extent of threats.
Yeah. Look, I really hope that we don't find ourselves in a place where we're seeking a compulsory questioning warrant for a minor, but if we look at the security environment that prevails today, regrettably, we see quite frequently at the moment instances where young people have been radicalised to the point where they're preparing to mobilise to violence, and so we certainly can't rule out the potential for us to seek a compulsory questioning warrant to avert a threat to public safety. So I think that hopefully that answers the first part of your question, Chair.
Thank you. And the second part, the more broader threat?
Yeah, so and then I'd return to some of the themes I covered earlier and just note that in the more diverse, the environment in which we have a more diverse range of threats, what that means for us is that we could have the requirement to use the powers under any of the heads of security. And, you know, I've touched on the 4 that have been added, but right now, politically motivated violence, foreign interference and espionage are the ones that are of principal concern to us. So there is very much the possibility that we will require a compulsory questioning warrant in respect of any of those 3.
Yeah, no, excellent. All right. And look, just lastly, I think the department touched on this earlier, but I did ask them about, you know, the argument that's been put, I guess, but the infrequent use of certain provisions, and you know, I think would have heard the answer from the department. But is there anything else from your perspective in terms of the bill and the other evidence provided from earlier this morning that you wanted to place on the record?
No, Senator, only just to note there was quite a fair bit of commentary around judicial authorisation. I think earlier on that I caught bits and pieces of, and I would just say it's consistent with ASIO's other powers that these are authorised by the Attorney General, and again return to the Inspector General of Intelligence and Security, who, yes, doesn't authorise those warrants, but provides that post facto look to ensure the appropriateness and proportionality of the actions of which ASIO is undertaken. So I think that's a really important safeguard that needs to be emphasised in relation to those powers.
Thank you, Chair. Maybe if I could, just 2 additional points I'd raise also. just following on from Mr. Warnes' point there, I think it's important to emphasise that questioning warrants are not covert in nature, as distinct from a number of ASIO's other special powers, such as telecommunications interception that the Acting Director General mentioned. It is, of course, open for the subject of the questioning warrant to make a complaint on the spot in relation to the conduct of questioning, or to bring a challenge, a legal challenge to anything done under a questioning warrant, which also I think just goes to the strength of the safeguards there. Which is important to note. I think the second point, just around the, I think some of the commentary earlier today, just around the level of information that is on the public record on ASIO's use of its powers. Probably also worth just pointing to the former Independent National Security Legislation Monitor, Brett Walker, SC's 2012 annual report, which contains some detailed discussion of Mr. Walker having reviewed all of the questioning warrants undertaken by ASIO up to that point, and his findings in respect of those warrants, including that ASIO had fully complied with all of the statutory requirements and safeguards, that the efficacy and the value of those warrants was well established by the intelligence that was gained, and that there was no evidence of abuse in the exercise of those warrants. Obviously, that report is a little dated now, but I think it's an important report on the public record from an independent oversight authority, in addition to the report that Mr. Taylor referred to and his evidence by the former Inspector General of Intelligence and Security.
All right. Well, thanks very much, everyone. Well, on that note, thanks for your attendance today. If there's any additional information or questions taken on notice, could you please provide that to the Secretariat within the time frame requested? We'll also get you a copy of the transcript for evidence from today's hearing. Now, there being no further questions or witnesses, I'll declare closed this public hearing.
Thank you, Chair.